much, Daniel. Firstly, can everybody hear me? Great. I think the numbers have dropped off a little bit, so thanks for coming. At least there are a few people left. I'm going to focus on the UAE in this presentation, and I'm going to really address the position here in terms of comparing litigation and arbitration and mediation within this jurisdiction. To start off with, just to get a little bit of an idea as to where we should be pitching this presentation, how many of you are based in the UAE? Can you put your hands up? Based or have ever been based? Let me rephrase that. Okay, so a couple of people. And how many people have actually litigated before? And how many have arbitrated? And how many have mediated? Okay, so we've got a good cross-section. Excellent. Now, if we're going to be comparing mediation and arbitration and litigation in the UAE, we have to start off by putting together some parameters. So what are our parameters for comparison? Well, what I would suggest to you is that there are several comparators that we should look at. The first is the result a good result? What is a good result? Do we have any views from the audience? What is a good result in a dispute resolution process? What is a good result? Offers from the audience.
A win-win situation for both the parties.
A win-win situation for both the parties. No, that's not a good result. A good result is where your client wins and the other party loses. That's a good result. No, I'm just partly joking. Let's look at some more objective measures for what is a good result. Have the parties had a fair hearing? Do they feel at the end of the process that even if the result is not in their favour, they have had their day, they have been heard by the tribunal or by the judge? Secondly, is the result comprehensible? Is it well reasoned if it's a judgment or an award? Can the parties understand why the tribunal or the judge has reached that conclusion? Finally, is the result enforceable? There's no point having $1 billion arbitration award if all you can do with it is frame it and put it on your wall. Yes, it's a nice piece of artwork, but it's not $1 billion piece of artwork, I'll tell you that. Let's move on then to some of the other parameters that we should consider in deciding which of these methods of dispute resolution works the best. Speed. Speed is important to clients. There's the old English adage, which is justice delayed is justice denied. A number of surveys which have been done amongst the business community in this jurisdiction and in other jurisdictions very predictably have found that the speed of a process is something that's very important to the business community, because the longer that parties spend within a dispute resolution process, the more man hours are spent, the more management time is spent, it usually becomes more expensive, and the result itself is postponed, and that is never a good thing. Next, the final parameter that we're going to concentrate on is cost. Generally, clients don't like to spend a lot of money on dispute resolution. There's a surprise. Dispute resolution lawyers, whether they be arbitrators or litigators, do you know what we're referred to? We're referred to as a distressed purchase. That's what we are. We're a distressed purchase. That's a terrible phrase, isn't it? It's like when your boiler stops working and you've got to buy a new boiler. Nobody wants to buy a new boiler, but you have to sometimes, because otherwise you don't get hot water. So just like the plumber, we are a distressed purchase. Now, so far as these parameters are concerned, there is a tension in between some of these parameters, because you can get a quick and well-reasoned judgment or award, but that might cost you a little bit more than if you get a award after several years, which is very poorly reasoned. That's just the nature of things. So let's look at the different processes one by one. Litigation. Litigation in the UAE. There are two types of civil courts in the UAE. You've got the onshore local Arabic courts, and you've got what are known as the offshore English language courts, the Dubai International Financial Centre courts, and more recently, the Abu Dhabi Global Market courts. The local courts over here, that's to say the local Arabic courts, have got a number of advantages. What are those advantages? Well, firstly, enforceability. If you've got a judgment in the local courts, it's unsurprisingly very easy to enforce that local judgment locally. The local courts are actually pretty quick. Certainly in cases in the local courts that I've been involved with in recent years, they're aiming to get a judgment out within 6 months, which is pretty impressive by any standard. Court fees, they're relatively inexpensive. There's a no costs rule, so the winner doesn't pay the loser doesn't pay the costs of the winner. So from a cost perspective, that can sometimes also make sense. In terms of the disadvantages, well, firstly, the documents have got to be translated into Arabic. Now, that's potentially a major disadvantage because, as we all know, things do sometimes get lost in translation. I was involved in a case in the local courts a few years ago where the other side translated a contract and they mistranslated the dispute resolution clause in the contract. So actually, the contract said that the jurisdictional clause in the contract said that the Dubai courts have got jurisdiction over the contract, over any dispute arising out of the contract. That's what the actual contract said. But it was translated as the DIFC courts. So the first thing we did was we made a jurisdictional challenge on the basis of the other side's mistranslation. So translation is very important, and we all know that documents in one language do not always translate well, because sometimes some of the subtleties, especially when you're translating from English to Arabic, some of the subtleties are lost when you do that translation, and also vice versa. When you translate from Arabic to English, it's actually quite difficult. The other disadvantage of the local courts is the use of experts. They like their experts over here. Has anybody been involved in a UAE litigation involving experts? Yeah? Good fun? She's got to be diplomatic because she works for a local firm. Well, experts are interesting. Now, the concept of experts in the local courts here is quite different to the concept of experts in, say, the common law courts in England or the US, because here, almost inevitably, the court will appoint an expert, and the expert will effectively decide the case, because the court will usually follow whatever the expert says. And the fact of the matter is that where you have an expert, that expert may not always be somebody with expertise in the subject matter of the case, because what often happens is an accounting expert will be appointed if the case has got something to do with numbers. So I was involved in a case a little while ago where it was an international trade case. So the subject matter was international trade, trade. Goods coming from one place to another. That's what the subject matter of the case was. But the court appointed an accountant as an expert. The accountant didn't know anything about international trade, and he asked us, the case had to do with whether certain goods had been delivered or not, and could we prove that they'd been delivered. And the first thing he said to us in the experts meeting was, well, I don't think any of these goods have been delivered by your client because there are no bills of lading. And so we all looked at each other, and then we looked at the expert and we said, well, there are no bills of lading because these goods were delivered by road. And you don't have bills of lading are when you have ships. You don't have bills of lading where you have goods delivered by road. So he didn't have expertise in the subject matter, but he was quite good on the numbers. So that all worked out fine in the end. But that just goes to show that experts are not always experts in what you need them to be experts in. You also don't have oral advocacy in the local courts, so clients don't get to come into court and have their day in court and feel that they're heard, because the system of advocacy in the local courts is very much memo-driven. So the local advocate will come into court, will hand up a memorandum and say, this is my case, and then the other side will ask for an adjournment and will come back in 2 weeks' time and hand up their memo. And so it's a very sort of memo-driven procedure that they have over here. And then finally, reasoning. What you tend to find is that court judgments in the local courts here tend to be a little bit shorter than you might find, say, in some other jurisdictions, in common law jurisdictions in particular, and are a little bit shorter than what you might find typically in an arbitration award. So they're positives of the local court and they're negatives. The English language courts, however, the DIFC and the ADGM, they're what you might call common law islands within a civil law ocean. Again, they have some advantages and some disadvantages. Enforceability is an advantage. It's easy to enforce a judgment within the UAE. It's also potentially easier to enforce a DIFC court judgment, for example, abroad, so outside of the UAE, because they recently came up with a rather clever mechanism whereby you could convert a DIFC court judgment into an international arbitration award. And then you take that international arbitration award and then you can enforce it under the New York Convention. But in order for that to work, the parties have to agree to the specific procedure which converts it into an arbitration award, which if you're the losing party, you will not do. So that agreement has effectively got to be reached when the parties are contracting, so at the beginning of the relationship. The disadvantage of the DIFC compared to the local courts is it's a little bit more expensive, because it is a common law driven procedure, and so you do have stages such as disclosure, although more limited disclosure than you might have, for example, within the US. So that deals with litigation in the UAE. What about arbitration? Well, the major advantages of arbitration here are quite similar to the advantages of arbitration in most other jurisdictions. The main ones being party autonomy. A party has input into the choice of their tribunal. They can choose non-lawyers as tribunal members if they want to. So in construction disputes, for example, Daniel, you do a lot of construction disputes, don't you? So sometimes in construction disputes, it's quite useful to have a non-lawyer as part of a panel of three, because you can get a construction professional who has a deep knowledge of the technical issues that are likely to arise within the arbitration. The other advantage, principal advantage of arbitration here is enforceability. So you get an award at the end of the day, which can be enforced internationally under the New York Convention. And an arbitration award is much more enforceable than, say, a judgment here, because there are a lot more countries globally that have signed up to the New York Convention that then have bilateral reciprocal enforcement treaties with each other. What about the disadvantages? Well, the disadvantages of arbitration within the UAE are firstly enforcement locally, because there are instances where the local courts have been reluctant to enforce arbitration awards over here. Although I have to say, in the last 9 years or so that I've been in this jurisdiction, there's certainly been a very positive trend towards enforcement. So generally, the local courts are becoming more and more supportive towards the international arbitration process, which is, of course, a very positive thing for arbitration practitioners who are based here. I'll move on finally to mediation, because I believe I'm running slightly short of time. How does mediation work in the UAE? Has anybody done a mediation in the UAE? Nobody. Okay. So historically, mediation is something that's quite widespread in this region. But the way in which mediation historically has worked has been quite different to the way in which structured mediation works in some Western countries. So, for example, the classic way of mediation used to be that you have two businessmen or two prominent individuals that have a dispute. What do? They then go to a third individual who isn't independent of the parties because he knows both parties. But it's his lack of independence and his position within the community which actually make that person so valuable as a mediator, because that person then brings the parties together and mediates the dispute. He tries to reach a resolution between them. And that's a form of mediation which has actually worked very well in this part of the world. Structured mediation, the sort of mediation which you find typically in some other countries where you have an independent professional third-party mediator, is something that has been less used, but you're now seeing more of here because there are a number of institutions which have been set up to support it. So most recently, the Dubai courts themselves have put together a mediation scheme. The DIFC courts have got certainly an encouragement to mediate. And more recently, there's been a mediation centre which has been set up by a number of the law firms and the government working together. In terms of the advantages of mediation, well, the main advantage is that it's consensual. So the result is only reached if all parties agree. So if all parties agree, then they've had input into the process and they should feel some measure of satisfaction that they've been heard. The other huge advantage of mediation which exists, and this is something that I've seen in practice, is that with a mediation, parties can be, often with the help of a mediator, much more flexible and much more creative in the solution that they reach to the dispute. So whereas the powers of a court can be quite limited, the court will have to rule in favour of one party or the other on particular issues. Within a mediation, one can be much more creative. So I was involved in a mediation some years ago where there was a dispute between two parties. The dispute related to a particular subject matter. And so if we'd taken that to court, the court would have ruled in favour of one party or the other. Both parties would have walked away. One party would have been happy, the other party probably would have been less happy. Within the mediation, what we were able to do was to say, well, okay, let's do a deal on this particular contract, but as part of the settlement, we'll give you something else, and we'll enter into another contract with you relating to a different subject matter. So those are the sort of things that you can do in mediation that you can't do within a more formal dispute resolution process, such as litigation or arbitration. Finally, I'd like to suggest one thing, which is that there is an inherent flaw in the title. So the title assumes that each of these forms of dispute resolution are exclusionary to the other. So you either have litigation or you have mediation or you have arbitration. The reality of it is that, especially where you have really large disputes, often you can have all three. So you might start off the dispute with a mediation where the parties try and reach a conclusion. If that doesn't work, you go to an arbitration. At the end of the arbitral process, you get an award. Once you get an award, if the other party doesn't pay the award, it goes to enforcement, which is in local courts. And then you might need enforcement or execution on the back of that, which again will be through the local court. So I think there is something to be said that the practical reality of matters is a little bit more nuanced. Thank you very much.